Are we ready? Is everyone good? Go ahead. Okay. All right, good morning, everyone. This is your last panel before lunch. So this is Immigrant Visa Issues, China and Beyond. So I'll introduce you to China and beyond. So my name is Ganesh Kalyanaraman. I'm from Sacramento, California. You see that Mr. Benjamin Chang, he's the Chief Immigrant Visa Section of Guangzhou. And Mr. Russell Brown, who you heard from the last panel, he's the CG, the Consul General for the Philippines. And then at the end, we have the esteemed Gary Chowder from Beijing, China. So I want to thank you all three for your time on this panel, and forward to delving into today's longest panel. We have an hour and a half to cover IP, so we can go at a very leisurely pace. The first question I had for both Benjamin and Russell is, if you just tell us a little bit about the IB applicant pool in your consulates, numbers, statistics, how many you typically see per day, per month, and if you know statistics of the types of IB cases you see.
Hi, Benjamin. That's the extent of my Cantonese. First off, it's a pleasure to be here. I'm a little bit under the weather, side cold, so if you give me coffee, I apologize in advance. So I've been in Guangzhou for about 2.5 years. It's a really exciting place to do a piece of work. I think in terms of workload, we might be number 4 in the world for US Post. Although I think we have more applicants than perhaps Manila, but Manila has a heavier workload than we do. In the last couple of years, we've actually seen a slight drop in our immigrant visa numbers. Last fiscal year, we did about 34,000 immigrant visas. But I wanted to point out to a very interesting fact. So we went back to US CIS to look at the number of petitions that have been filed by Chinese nationals. And actually, in the last decade, the number of immigrant visa petitions that have been filed with USCIS has actually been growing. And in fact, in the last 2 years, the numbers of petitions are at record high. Now, we haven't drilled down into the numbers and into the data to see what the categories are exactly. Now, for example, if 80% of these petitions happen to be for siblings of US citizens, well, we're not going to see these applicants for another decade or more, right? But what I'm trying to say though is, even though our workload has gone down a bit in the last few years, I think that's because of processing, because of visa types, and we do expect to see the workload continue. Mainly we see family-based visas, IO1s, IO2s, CO1s, CO2s, and IO5s. Along with a lot of family members of LPRs. And of course, everybody knows that Guangzhou does 85% of the world's EB5 investor visas. So that is something unique. So in a nutshell, that's what happens in Guangzhou. We have a fairly large unit, about 10 officers interviewing Monday to Thursday. In the mornings, and then the rest of the time we're busy doing processing of the cases at each individual office's. I'll be happy to answer any specific questions you may have. Thank you.
Yeah, so Manila, as those of you who sat through the previous panel heard me say, is we're old folks. We've been around a long, long time. And we've been in the business of immigrant visas for a very, very long time. Currently, the stats on people of Filipino heritage or that still are Filipinos in the United States is more than 4 million. Okay, so we are talking about an extremely large group of people, and that that pull to immigrate to the United States, family unification or for work, continues to be there. And so we are still the third largest, I think, by processing volume, not necessarily by issuances for IDs in the world, after, of course, Ciudad Juarez number one, and San Domingo is number two. Little old San Domingo is number two. But in terms of total workload, we also include K visas, because at our post, even though K is the non-immigrant visa category, we have the immigrant visa unit process them. So we're about a little bit over 55,000 immigrant visas last fiscal year. This also includes a slight drop. I think that the worldwide numbers sort of ebb and flow. I think a lot of that has to do with DHS processing. I also think it has to do with the ebb and flow of the primary immigrant, so the person that came, when they came, what kind of numbers were available in the time that they came, and so on and so forth. And these, ripple out decade after decade, and particularly when you're talking about a post like Manila, where the wait times for, let's say, an F4 or something like that, a family fourth preference or something, can still continue to be 26, 27 years. Then we're talking about long periods of time. So the ebb and flow, I agree with Benjamin that this is something that we will see a dip in for a while, but we will continue to increase. We are the largest number of E3s, so you have E5s, we have the largest number of E3s. This is the nurses and physical therapists and the doctors and all of the healthcare workers in the world. So nearly 50% of the world's total are Filipinos, are processed in Manila. We're number one in the world in terms of fiancé visa volume, more than 8,000 last year, and this continues to grow. So as I always say to my speeches out to various groups in Manila, we are definitely in the business of love in Manila, our embassy on our hospital work. So adoption is also something that we have been working very, very closely with Philippines authorities on. Philippines became a signatory to the Hague Convention on International Adoption a couple of years ago, and they've made extraordinary strides in terms of tightening up adoption procedures and following the structure that the Hague provides in that. And last year we had issued around 100 visas for children legally adopted by American families. Let's see what else to tell you. So we continue to be one of the largest consular sections in the world overall. As I had said earlier on the fraud panel, IVs are 900-pound gorillas, so they are the bulk of our local staff and the bulk of our officers because of the nature of the work. And IVs were probably about 15th in the world. We're not anywhere near the top 10, but at $250,000 a year, that's significant. And those numbers actually are rising, which then tells us, of course, that in the future we can expect that unless there is a big change to the law in terms of family reunification in particular, we will continue to be in the business of IVs for a very, very long time. And then American Citizen Services, of course, is our largest part. But that's what we're here to talk about, IVs. So thank you.
Absolutely. And so I know in Manila, you divide your 900-pound gorilla daily by 9 appointments. I think the last time we spoke, you stagger them, putting returning residents first in the mornings, and then
I absolutely
speak a little bit on that.
Specific to that, sure. So we have IVs at one of 9 different times. You're right, Ganesh. So we start with our first round at 6:40 a.m. and then it's every half hour. Beyond that, that's
the returning residents. They really need to be committed.
The returning residents we do at 8 a.m. So we're a little bit kinder on the returning residents and at 8 a.m. We also stagger in a couple more between then. So it's basically 6:40, 7:10, 7:48 for returning residents, and then we continue the half hours at 8:10, 8:40, 9:10, 9:40, and then we stop at 10 in the morning, which means one of the things we want to do is to make sure that we aren't having people hang around and hang around and hang around. And as we all know, with any kind of large processing organization like this, whether you go to the Department of Motor Vehicles or you're at the airport or whatever, the longer you go throughout the day, the more that things happen and delays occur and phones get answered and people, have other stuff to do and so on and so forth. So it's always more efficient, and generally the experience is more efficient first thing in the morning. And so we see a lot of diminishing returns if we go too far out into the day.
And so typically how many officers do you have?
Right, we have 3 managers. So we have 3 mid-level managers now. We actually were added third mid-level manager in fiscal year 2015, and that person arrived on the scene in 2016, which shows that our growth relative to other ID processing around the world. Consular Affairs does its staffing based on worldwide metric, and so someone else's loss is Manila's gain in terms of that, and China is runs the same way. So it's definitely a global approach to staffing and workload. Then we have somewhere between 12 and 13 adjudicatory officers on staff at any time.
Thank you. Have a well. So both appointment timings as well as staff.
So as far as appointments, as I mentioned earlier, Monday to Thursday, we have the earliest come in at 7:45 a.m. and we try to work all throughout the morning. We don't have specific times for specific categories. It's whatever the scheduling that the National Visa Center gives us. We take care of that. We don't do any interviewing on Friday because that's the day where we need to catch up on what we call back office. Now, for returning residents, they come Tuesday afternoons, as well as what we call comeback interviews. So we need to re-interview somebody to get more information. That we set it up for Tuesday afternoon. In certain emergencies, if our communications team gets some contact, we can always be flexible to fit somebody in on a certain afternoon because something's going to expire or for humanitarian reason. We also mentioned adoptions, and that jogged my memory. I forgot to mention adoptions. So, we also do adoptions in Guangzhou. Guangzhou is number one in terms of adoption visas. We did about 1,906 last fiscal year, and that's actually a decline from a decade ago when numbers were as high as 6,000, 7,000 a year. And part of the reason I think is Chinese economy has gotten much better. People's attitudes are changing, so certain orphans are being adopted locally by Chinese people. And per the Hague Adoption Convention, Chinese nationals will get first choice to adopt Chinese children. So most of the children who are adopted by Chinese are going to be healthy babies. So the rest of the kids adopted by U.S. parents, I would say 90% of them are long-term special needs with various medical conditions.
And do you guys accept applications for third country nationals? And if so, where are they typically from? And are there any countries in which we do not accept third country nationals for ID applications?
Well, I mean, if a person is living in China and they want to have the interview in Guangzhou, that's fine. We will accept it. I don't know if there's any case where we've actually said, no, you have to go back to your home country to do the immigrant visa interview. I think the trick there is people petition for the family members to immigrate. In Guangzhou, there is co-located in the consulate is a USCIS office. So if somebody is resident in China, they can actually file a petition at the U.S. consulate in Guangzhou. I think there's a USCIS office also in Beijing. So if you're close to Beijing, you're resident in China, you can file a immigrant visa petition through the website in Beijing. Now, the definition of resident does vary a little bit. Obviously, if somebody has just flown to China, met the love of his or her life within 2 weeks, I don't think USCIS is going to accept that petition. But if you're on a resident permit, you've been working in China, you're a student, I think USCIS, I don't want to speak for them, but I've seen them quite flexible. In those cases, obviously,
I'm doing your job, Jeremy. Your old job.
Guangzhou, sometimes within 5-6 months of the filing, if there's nothing, there's not a wait time involved.
Likewise, we accept ID applications from all third country nationals resident in the Philippines. Part of your question was what kind of nationalities are we seeing? Well, we're going to see Chinese.
I was going to let you listen. You want to listen?
No, but Manila is a global city, and basically everybody is there. And so as long as they're resident in the Philippines, we will accept them. Likewise, we have a USCIS office in Manila. Keep in mind that their overseas presence is tiny, and our Manila office, we have 2 officers, 2 adjudicating officers is considered very, very large for them. And so they will take applications from folks who are resident in the Philippines.
And so it's been about a year since President Trump signed the executive order on Buy American, Hire American, what we affectionately call BAHA or BAHA EO or BAHA OO. Has that had any impact on third country national processing or anything? Has BAHA had an impact on any ID process?
So, Ganesh, when I first got the questions via email, I had to look at BAHA. So I think, at the working level,
So it's safe to say it's a daily concern.
so yeah, as far as daily processing, I can't really say that that's what it looks like guidelines.
Yeah, likewise, no idea what you're talking about there, but figure it out, and no impact whatsoever.
And then I just want to talk about expedites for ID appointments. So what's the best way to request an expedite with post? And how much credence do you give if the request
When we don't have anything on the screen, that's wrong. Or is he picking that?
Okay, so my understanding is all the expedites have to go through NBC.
Yeah, I turned it.
Although if somebody emails us directly, we would certainly take a look at it carefully and consider it.
Turned it on.
I think Guangzhou's record shows we have been actually quite flexible and willing to do expedites for ID interviews. Obviously, if anything humanitarian reasons, we would say yes to medical emergencies. Another thing we see very often is, IR5's parents are considered 2 separate petitions. And for whatever reason, sometimes with NBC, the 2 files get separated, or they're scheduled separately. So people ask for an expedite so that the 2 parents can come in and interview on the same day. That's a no-brainer. We say yes to that. And then another thing is we do look at financial hardship. That is something that if a person has a Chinese family and they've gone back to the United States, and they make a convincing enough argument that it's hard to maintain 2 residences while they have to support the family in China. That's something we definitely give very strong consideration as far as an expedite.
So for us, it's really just about where the petition is in the process. So if it's still with USCIS or NBC, of course, then you, as Ben said, you send your expedite request to that particular stakeholder. For NBC expedites, the NBC will ask us to approve or deny an expedite request. And as long as we in Manila have the capacity to handle the incremental volume, our track record is just about 100% on approving those. So once we have the petition at post, IB applicants can request an expedited appointment, and we evaluate it on a case-by-case basis. But since generally we have local appointments, so there's two different types of scheduling, NBC schedule and then our power to schedule local appointments. We're pretty available in Manila. Usually it's about a week for locally scheduled appointments. So if the expedite is needed quicker than that, there's going to have to be some really strong, compelling evidence of what that's all about. Because generally an ID shouldn't be quite that quick.
And would we be able to submit the expedite request post by email, or what's the best way for us to?
Yeah, certainly an email. But I will try to give you an email address later. But it's not a standard email. It's what we call a web form, where you go on the website and then you have to fill out the request and then press submit. So for me to read it out, it's really kind of long. So I'll give that to you later. So you can share.
Just a couple of follow-ups. One, for the web form, there's a limited number of characters that can be entered, kind of like Twitter, 360 characters maybe. What if somebody who's an attorney who's a little bit long-winded wants to do more?
We do have another email, which is, I'll find it. I think it's something like Guangzhou ID ad info@state.gov. We normally give that out for people when we're requesting resumes and additional documents after we've gone through the first interview. Yeah, Guangzhou ID ad, that's ADD info@state.gov. Communications team receives that. I do want to mention a kind of amusing story about an expedited request I got about 6 months ago. The petitioner had written to NBC saying, we really desperately want this expedite so that my wife can come in because she's pregnant. And if she gives birth to a child in China, that child will not qualify to become president of the United States in the future. I believe that is actually an incorrect reading of the Constitution, because the Constitution says you have to be a natural born American. So he is going to be a natural born American in China.
The Supreme Court does not.
But the Supreme Court has not made that decision. So that kind of put us in a bind. So you have these parents with very lofty expectations. But I won't say how we did that, what determination we made. I thought that was one of the more interesting expedited requests.
But just to follow up on that, one of the common questions we get when a couple is pregnant is, can we expedite the IB so that the wife can give birth in the US?
Good question. Again, case by case basis, right?
Depends on if they could be president or not.
Yeah, I mean, we will look favorably at most of these situations and say okay. But like Russell mentioned, sometimes we have to balance our workload, and we do see a ton of expedites and. What's more important? Somebody who has a medical emergency versus giving birth.
And Russell's the best way, the email address ID Manila replies at state.gov.
Yeah, ID Manila, not ID Manila replies. It's somewhere in my notes. So I was trying to find that. I had the intention of bringing generic business cards that have all of our contact info, and I was just in a panic looking for them, and I think I left the box somewhere. But somewhere in my notes, let me look for them and I'll get back to you. My staff gave me 2 email addresses that folks still continue to use that don't work. So I just want to make sure that I'm giving the right one out. So I'm not giving you that info. But in terms of expedited requests, as I said, we don't really have a problem in Manila if you have if there's a compelling case for post-scheduled appointments. We're going to take care of you in general. It doesn't really matter what the situation is. And by the way, I'll just say, I was born abroad, so I have a consular report of birth abroad. I was born in Istanbul, Turkey. So the question, if I could become president, which is highly unlikely at this point, the determination has not been made. But if John McCain, right, had been elected, there would have had to have been a Supreme Court decision that would clear that up altogether, because he was born in the Panama Canal Zone. So was he born a natural-born American or not? Right. So the idea is, you can go into this aside, but the idea is that you became an American at birth, right? So that's the whole point. Which he did, and I did, right? Because we were born to American citizens abroad. But the Supreme Court has not made that determination. The intent, right, we think, was that you could not have, basically, they didn't want Alexander Hamilton to become president. Because he was, in essence, born in Bermuda, and he was an immigrant to the US, not born on American soil. That was the original idea, but who knows?
Well, I cannot be a president because I'm naturalized.
Here, President. So continuing on our MythBusters panel. Stateside, we've seen kind of a delay in interviews for IVs. Have you seen an increase in consular processing? How has the trend been over the past year or year and a half as far as IV adjudications, cases you can see? No.
Oh, you're asking?
No,
like I said, so we only did 34,000 visas. That's it. A couple of years back, we did 55,000, right? And about 1,000 cases. So obviously, there's a delay, right? NBC schedules, I think 85%, 80 to 85% of our interviews. So we're really at the mercy of NBC. And if NBC is not giving us cases, we can't do any more. We have the staff, we have the capacity. So and you have to understand, at the concert, we're at the tail end of a very long process, right? It starts with USCIS, goes to NBC, depending on what it is, it may go to KCC, then it comes to the concert. So NBC's been scheduling numbers. We can do, let's say, up to 300 applicants a day, but we're just not seeing those numbers in the last 8 months. So certainly, I think there must be some delay, on that end.
Yeah, I think that's right. I think that we are all sort of at the mercy of USCIS capacity to get through their cases, and depending on what their funding is like, a lot of this is very opaque to us in terms of what their funding is, what their staffing is, how, whether or not such and such service center is more burdened than another. I think probably those who have been like you, who've been doing this for quite a while, know which service centers are faster, which are slower, so a lot depends on where it's originating, which service center the petition was funneled through, and that kind of thing. And then, like I said at the beginning, there is definitely an ebb and flow in terms of IDs over time. And I think that we're seeing these troughs in adjudication abroad because there is probably, I'm guessing, a wave of cases that are coming in that need adjudication. And so, so as the tide comes in and goes out, we're seeing, pent-up demand on the USCIS side that will then translate presumably to more work for us abroad in the near future.
All right, transitioning over to employment-based cases. I know many. Oh, do you have an email?
Yes, I'm terribly sorry. I'm a very unorganized person. So, right. So, immigrant visas, IV Manila replies at state.gov. IV Manila replies, and then please do not use the following email please delete them from your auto response and that kind of thing. So there is no more cons ID Manila or ID Manila attachments, which to me seems kind of a silly email anyway. But cons ID Manila and ID Manila attachments are both gone. There is just ID Manila applies. And we have a correspondence unit now. We've always had a correspondence unit. In the last year or so, I combined our non-immigrant visa and our immigrant visa correspondence units, and we're quickly moving to put our American Citizen Services correspondence in there too, and that is what we call the Concert Communications Group. So if you see a reply from Concert Communications Group Manila, Philippines, that is not fraud. That is actually our correspondence unit. So they named themselves, they wanted to be called the CCG, the Concert Correspondence Group. So they will handle the bulk, by the way, of your replies. So asking for an officer to reply or trying to get into an officer or something like that probably isn't going to do you any good. Just assume that your responses will come from the good folks in the Concert Communications Group. And in answer to one of the attorneys asked earlier about should I wait if I don't get a response, if I'm, and this happened to be for NIV, but if you're not getting a response, contact us again. We have no problem, and nor should we have a problem with responding to your inquiries. That's what we're there to do. Okay, so if you're not getting the answer to the question that you need, ask us again. Something has obviously gone wrong or something like that. We are doing metrics within the Concert Communications Group also to make sure that we don't have missed responses, that we are answering people's questions, and we are getting back to people as quickly as possible.
So transitioning to employment-based cases, I think probably the concerns on either of your offices are probably different due to the applicants there. So Russell, with regards to the Pizza Hut PB3 for a computer scientist or working at a chicken coop. What other concerns has ED cases presented? Are you concerned with familial relationship with the company? What other kind of red flags are there?
Well, I think it's the standard stuff with that you're as familiar with as I am or more in terms of is this something that we can assume is actually genuine? Is this person actually doing what they say they are going to do? Does what they said to USCIS in the initial filing actually match what they're telling us at the window? And sometimes there is that disconnect. Sometimes we find, of course, in the course of the interview, that this person has been doing very different kind of work or is not qualified in any shape whatsoever, in any way whatsoever for the work that supposedly they are purported to be able to do. And they'll admit that, or it comes out, if there's suspicion, it goes over to our anti-fraud folks and they find this stuff out. And then obviously we're in the position of returning the petition.
And Benjamin, you didn't get a chance to be on the fraud panel. What other, as long show in your concepts see as far as employment-based side or fraud issues in general?
So for employment-based visas and fraud, what we see the most are the E3 cooks, chefs. Apparently there is a huge need for Chinese cooks in the US.
The food has been good.
But I mean, you have to qualify, of course, to be able to cook this. So you have to be able to talk about your abilities. And during the interview, some people so during the interview, some people can't even talk intelligently about cooking simple Chinese dishes. I mean, come on. You're a chef. You're supposed to be able to time many. Talk about courses of, major courses for banquet, things that I think a lot of us are accustomed to. When we can't talk about that, we're going to have to investigate further. And in our fraud investigations, we found we found several where the person is not actually a chef, but like a line cook. And it gets a little difficult in terms of trying to determine, are they really qualified? Like Russell said, if it's been approved in the petition, we're going to assume you are qualified. So be honest and tell us if your skills match up with what is listed in the petition. We don't want to have to go on a fraud visit, and we've done several of these, where the cook comes running out, and we're like, who's this? He can't name a single person in the restaurant he proposes to work in. He can't name what was on the menu last week when we've already talked to a different chef in the same restaurant. I mean, these are all indications that I'm going to have to send this back for verification. So these are a very difficult category for us. If I'm on the line interviewing, I don't know about cooking, okay? I know some things. I know about eating more than cooking. But I know enough to ask you some questions. And you know what? We're not trying to make things difficult. If you can talk semi-intelligently about cooking, you're probably going to be okay. We can't go and check out of every single restaurant. But if you give us any doubt, we're going to send it to FTU to look deeper into the case.
And also just speaking about fraud, and I know Russ, you touched about this on the previous panel, but the 90-day rule for fraud and intent. To what extent, during the immigrant visa are the frontline officers, told to look into the previous entries perhaps and what their immigrant intent was then, and what they worked.
Sure. Yeah, as I said on the previous panel, look, it really is case specific. It really depends on the materiality of the misrepresentation. Should there be misrepresentation? We're not probably going to try to, in general, we're not going to try to play gotcha with folks who have made it that far up into the system. If you are to the point where you're presenting yourself, particularly for family reunification, for an immigrant visa, that's been a long wait. There's been a lot of water under the bridge. Lots of things have happened. Are you the person that you say you are? Okay. And does the relationship exist? That is the basis for the immigrant visa itself. Yes. Okay. So beyond that, we're probably not going to go into too much. Now, there's other things that may arise in the course of the interview. There may be other things that that cause the processing to to be delayed for some reason, or somebody's behavior while in the U.S. may make itself known into our systems and things like that. Prior criminal records, things like that. But in terms of what you're talking about here, which is initial intent, the likelihood of our really being able to delve into that in most cases is not going to be that great. However, that's not to say that we wouldn't do so, because it's still, an issue. So it goes back to that whole thing of materiality. Does the material misrepresentation rise to the level that it needs to be, that we need to respond in that case? But in general, it just depends.
Any impact 90-day rule?
I have to be honest, I actually haven't seen much of an impact at all. I think the impact might actually be more on the NID side.
That's transitioning on to the K1 issues and marriage issues. Besides the fairy divorce, which I just found out about today, the very same game. Besides annulments, is there any other process that you've seen that an individual can properly terminate his or her previous marriage in order to continue an IR case?
Right, so you're talking about the marriage that is void ab initio, right? And so is the K1 beneficiary eligible even without a court declaration? That's usually the basis of this question that attorneys have. So this really depends on where the person is getting married, which state in the US they are planning to get married as case, because different states have different laws about this. So for example, I have an example here. A Filipino beneficiary to a K1 petition married in the Philippines many years to a Filipino man who, unbeknownst to her, was already married. When she found out about it, she left the Bigos for good, but never sought nullification, official nullification of this quote-unquote marriage. So the issue was whether the beneficiary needed to get the void ab initio marriage nullified to be able to get a K1 to marry the AMSA petitioner in the home state in the US. And this happened to be a state that did not require nullification of a prior void ab initio marriage. But in the past, in this example, Manila was using a Philippine Supreme Court case called Abonado versus the People to deny the K1, reasoning that even though the prior marriage failed ab initio, the additional step was required. The nullification was required. But in fact, Consular Affairs, our friend Jeff Horsey, who sadly not doing all this stuff anymore, but our legal advisory opinion section in
Sad for you.
See, that shows you we have a relationship. Different perspectives, but in fact, VO said at that time, the family law of the receiving state controls. Okay, so it doesn't matter what Filipino law says. That has nothing to do with the case. It is what is the law where the marriage will take place. Okay, so what is the law in the state of blah, blah, blah. Okay, so does that give you an example of how that might work?
Absolutely. But I want to just delve more into the K cases. So, during a K interview, that a K1 fiance interview that's found to be, deniable. What is the process to?
I don't think you have to be diplomatic. What are you trying to say here?
Well, I'm trying to say, is there, considering that it's treated sometimes like an IB, sometimes like an NIB, is there a possibility of holding on to the petition before it's sent back to USCIS for revocation to address any issues that may have come up during the K? Is there an opportunity, after the denial of the K, for it to not have such a quick turnaround to send it back to USCIS for revocation?
Well, actually, I think Gary and I, we had a case, right, where Gary reached out and provided additional information, which I thought I reviewed the case and it was actually convincing, and I consulted with the officer, and he's like, yeah, well, it would have been good if he actually mentioned these things. So, but anyway, so my understanding is the K petition is good for 4 months. And when we find something that is not to the competent officer's satisfaction for the K1 visa, we are going to revoke it. Okay, so we're denying it. We're going to send it back for revocation.
And how long do you typically keep a petition before you return?
That depends on the individual officer, how efficient he is, how quick she may be. But I have to admit, we have seen cases where we have sent it in for revocation, maybe a month, maybe 2 months after the denial, and USCIS does not act on it. And then 6 months later, the same petition comes back. A new petition is filed, but the same petition is for the same applicant. And at that time, we will reevaluate the case. And when that happens, there's probably more information right there. Likewise, we've seen K1s where we've denied it because officer wasn't satisfied. And then shortly after, they come back as a CO. So, oh, great. So maybe shouldn't have denied it, but it's also up to the applicant to be able to talk intelligently about the relationship. So as far as holding on to it, which is your initial question, probably on average, we don't hold on to it for more than like a couple of months.
I think that for K's in particular, we're not going to hold on to them for very long. First of all, our volume is so immense, and I'll be direct, as I like to be direct, in saying our experience with K's and our experience with Filipino applicants allows us to draw some pretty quick conclusions about whether or not this is a valid case or not. And so, to be honest with you, we're going to turn that around for revocation pretty quickly. So you might have about a 2-week window to get more information in, but in general, if the case is not clearly convincing on the face of it for us, it's probably not going to get better with time.
And would you ever consider issuing a 221G for a K? So,
well, I think that that's always dependent on the case. I think we do 221G from time to time. But in terms of holding on to, the window of time to somehow bolster the case is going to be pretty short.
Understood. Did you have any recommendations on how, as practitioners, we can follow up on perhaps cases that have been delayed or either stuck in not administrative processing by a different government agency, but administrative time between the interview and the visa royal page? Besides the emails, is there any better way to follow up with those cases?
As Gary knows, we're very open to whatever inquiries come in. We'll definitely take a look at them. If you're not getting an answer, like Russell says, please don't hesitate to re-email us. Sometimes, just because of our workload, we're not able to get back to you as quickly as we would like. I think when you come and present additional information, you may have a lot of information, and a lot of it is based on the law. But I think our officers appreciate it if you come in with like a summary in the beginning. That is it summarizes your argument, and kind of like an executive summary to a long 100-page report. When you give us that summary, that will allow us to focus on what the argument really is. And if we need to go look at the additional or the supporting arguments, the citations in the FAM or citations in the INA, afterwards we'll look at those. But it's a way of like coming in and writing your argument so that you get to the focus right away in a very tight executive summary, and that actually helps us do our work very well.
I would agree completely.
And so, are G28s required or recognized for the IB queries? And what is the best way to submit a G28 to your instance?
An attachment to an email is fine.
Okay.
Or if you have the hard copy with the applicant in the applicant's file. But we would really like to look at the G28 just to make sure that this person is actually being retained as the lawyer for the case.
Yes. And then if the G28, if it's been submitted by the attorney, what is the best way to but feedback's been received that, that your office is still waiting for a G28. That's the best way to ensure that a G28 has been attached to that case.
Are you saying that we're still waiting for the G28?
The G20 has been submitted by the attorney, but due to when follow-up has occurred, in general, they've been told that the G28 is still not on file, so you have to resubmit it. Is there another process? Is there another email that for such cases, just for attorneys, or to ensure that a G28 is
I think it just be the usual mailbox that you communicate with us with.
Yeah, I agree, just resubmit them. It's entirely possible, when you're dealing with tens of thousands of cases in the pipeline that, stuff gets misfiled, misattached, those kinds of things, just resubmit.
wonderful. Gary, do you want to go through your?
And on G28s, let me just say, and this may be common sense, but I think we find that sometimes attorneys assume that the G28 is attached to the case by USCIS and don't assume that. Okay, so more is better, right? So more communication is better. Don't be shy about sending more information to us. Yes, obviously the G28 should have been with the case when it came from USCIS, but stuff gets lost. From time to time, it doesn't get attached to the right case. It gets left off when the PDF is uploaded, those kinds of things. So by all means, go ahead and
So when an attorney submits a query, just put a separate attachment just saying G28 on it. Can't hurt, right? Yeah. All right, good practice, Lauren. Here.
All right, now we're going to geek out a little bit, talking about the ground of admissibility for communist and totalitarian party members. Think that, how many members would you guess there are of the Chinese Communist Party? About 90 million. So you can imagine this is an issue of pretty widespread applicability for IV cases coming out of China. This ground of admissibility has always been controversial. The first time that it was added explicitly that Communist Party members are inadmissible was the Internal Security Act of 1950. And at the time, President Truman vetoed the act, saying that it makes a mockery of the Bill of Rights and of our claim to stand for freedom in the world. The Congress overrode that veto. I'm going to give just a 1-minute background so that we can get into questions and answers with the callers. So the ground of inadmissibility is found at INA 212A3D, and it's for membership or affiliation with a communist or totalitarian party or any affiliated organization. It applies to IVs and Ks, but not to non-immigrant visas. There are exceptions. One is for past membership. It's membership that terminated 2 years before the application, or 5 years in the case of membership in a party controlling the government, like China, Vietnam, etc. There's another exception for involuntary membership, and then there's an important judicial gloss on this. The Supreme Court has said that even if an applicant is mentioned on the party rolls, it doesn't count as membership or affiliation if that association with the party is non-meaningful, considering such factors as whether the applicant is committed to communist ideology. The leading case on that is Rowell versus Perfetto, 1957 case, ROWOLP. Finally, in this real quick outline, there is a waiver, and I-601 can be filed with USCIS if there are certain U.S. citizen close family members of the applicant, that's a parent, spouse, son or daughter, or sibling, or if there's certain permanent resident family members of the applicant, that's a spouse, son or daughter. And the waiver is discretionary, can be granted based on humanitarian reasons to assure family unity, or when it's otherwise in the public interest. So that's it for my summary. Let's get into the Q&A. So
before you start asking questions, I forgot to mention, if anybody has any non-case specific questions, feel free to write it down and bring it up. It's very deep subject.
So when Donald Trump was a candidate and after he became president, he's called for stronger ideological litmus tests as to who can immigrate. Since he took office, have there been any changes to the law, to the rules that ban or practice related to CCP cases?
So in China, this is something that we have to evaluate for every single Chinese citizen who wants to immigrate. I have to admit, I mean, until we see actually strict guidance or change in the regulations, it's really we're processing the cases as normal. So I can't say that there's actually been a concrete change.
So stay tuned for more in the future, maybe. Back in the 1950s, Senator Joseph McCarthy claimed to have exposed the number of card-carrying members of the Communist Party. In China, if you're a party member, you carry a card.
I am not aware of a person who has to carry a card.
If you're an attorney who wants to do due diligence and figure out if your client is a member of the party, is there a website that you can just go to check?
So my understanding is there might be a website listing like the 2,000 most important Communist Party members, but I don't expect to see any of them at my interview.
So the ground of inadmissibility covers not just members of the party, but also members and affiliates of affiliated organizations. In China, affiliated with the party, there are these things called mass organizations and people's organizations. For example, the Communist Youth League is for people ages 14 to 28, and it has about 70 million members. Another example is the All China Federation of Trade Unions. It's a sole national trade union with about 150 million members. Both these organizations are led by the party. So if people are members of these organizations, is that going to impact their application for immigrant visa?
It could actually, because it's still under the guise of the general CCP. So if you come and tell me that you are a member of the Chinese Democratic Party, we know that the Chinese Democratic Party is only allowed to exist because of CCP, to give the guise that China is actually a multi-party state. But we obviously look carefully at whether your membership is meaningful or not meaningful in these related organizations.
In the US, there are groups on college campuses called Chinese Students and Scholars Associations, or CSSAs. They do things like welcoming Chinese students to campus, helping them find a place to live, etc. But the FBI has also reported that some CSSAs are subsidized and directed by the Chinese government. Is membership in a CSSA a ground for admissibility?
I have to say that we have to evaluate on a case-by-case basis. I think you can be a member of a Chinese Communist Party or one of the affiliate organizations, but it really depends on what you do with that organization. If your job is to help recruit members and you're actively trying to promote the Marxist-Leninist ideals, then I would say your membership and your work is quite meaningful. I've talked to people at the interview window before and said, well, what do you do when you go out for your meetings? And he says, well, you know, our meetings are, we sit around, we go to dinner, and then we play badminton together. I mean, to me, yeah, exactly. It's a social club, right? So I don't know, I feel like a situation like that is not that meaningful.
In the US, there are several universities, a large number of universities that have joint venture relationships with Chinese colleges. And it's been reported recently in the media that at those US schools, there have been set up Communist Party organizations. For example, University of Illinois, Urbana-Champaign, UC San Diego, UC Davis, University of Bridgeport, Connecticut, Ohio State University, Northern Illinois University, etc., at least according to media reports. Have you come across cases where people have been found inadmissible due to membership in Communist Party organizations in the US?
So far, no, I have not seen any examples of that. Most of the Communist Party members we've seen are probably like older IR5s who joined at one time because it was necessary for their employment. And then we just ask them, you know, what you do. And, if you're like in a small, like kind of village or prefectural level state-owned enterprise, yeah, that to me is not really a meaningful membership situation. If you're working for a large state-owned enterprise and you are in a position to make hiring and employment decisions, then we're gonna have to look carefully. So for example, if, let's say, Russell and I were working for the CCP, the difficulty is to make that determination. How meaningful is our association, right? Obviously, the ambassador, the consul general, or the consulates, that's clearly meaningful. But would a entry-level officer be considered meaningful? And so it's really a judgment call on the part of the consul officer when we evaluate these cases. I want to emphasize that when we look at it, we don't take it lightly. We actually have a team that sits down and deliberates before we make a decision.
Tell me more about this team.
Well, I'm one of the members of this team. And then we have an officer who has his portfolio, and his job is to just research as much as possible to learn about the Communist Party membership structure in China. And I want to let everyone know that we're here to enforce the law. We're not here to play some sort of contract game to find here comes somebody, we're going to go after you.
I want to turn to the first exception to inadmissibility for terminated membership. How do you know if somebody's membership has terminated? In other words, what's the definition of termination? Let me give you two examples. One is that the Communist Party's constitution has a definition of termination. It says if you stop participating in activities and paying dues, etc., for 6 months, you may be considered to have abandoned your membership. Another is this definition that you've been mentioning about non-meaningful membership. So let's say you were a meaningful member, and then at some point you became a non-meaningful member. Maybe you retired from your job, but you're still a party member. Is that termination?
So the termination is if you stop paying dues for 5 years, you're no longer a Communist Party membership. It's obviously very difficult for us to check on who has stopped paying membership dues. It's always very curious when we talk to the applicants. We ask them, "Are you a Communist Party member?" And they're like, "Well, I was." And then, "Well, when did you stop being a member?" And they, more often than not, will give you a date right around the 5-year mark.
That's because they waited to apply for that until 5 years ago.
There you go. But let's say you were a meaningful member, you've been retired for 10 years, and you continue to pay dues, then I think you're still considered a meaningful Communist Party member based on the activities that you engaged in the past. But I think in those cases, the waiver is more likely to be granted.
Right. Now, the FAM is real helpful on this, and for anybody working on these cases, take a look at FAM. It's got a lot of details. One of the things it says is that if somebody credibly asserts that their membership terminated 5 years ago, then the officer should normally accept it, absent contrary evidence. Seems pretty nice. What if the consulate does require some evidence of termination? What is the consulate going to ask for?
Well, we're going to ask them if they can provide some sort of note, and we want to be careful because if you ask for some proof, usually people will be able to give you some note with a stamp on it. So what we usually do though is we ask for this. We ask for your travel history, and by looking at your resume and travel history, we can come up with a pretty good determination of your activities, while you were working. And let's say you've been retired for 15 years, and all this travel has been to Southeast Asia, and through maybe a second interview, it's not an exact science, right? So we talk to you, and if we have a certain level of comfort, we're not going to find you a meaningful Communist Party.
Let's take a look at the second exception for involuntary membership. You mentioned people who joined the party decades ago. These days, are there many people who join the party involuntarily?
I don't know. My understanding is if you are a very good student in China, they will try to come and recruit you. But that also depends on, it's hard to say with the Chinese students today. Some people are I think these students are practical. They want to get a job, right? So if they get recruited, they're like, well, maybe I can go work for a good state-owned enterprise. Okay. And I met plenty of youths who the people try to recruit them and they couldn't even make it to the first meeting and they would automatically cut out. So your question is, are they voluntary?
Yeah. So these days, people coming into the party, is there anybody who could convince you that it was involuntary?
I think it's going to be much more difficult nowadays. 30, 40 years ago, just to be able to subsist, to eat, to have a semblance of decent housing, you probably had to join the Communist Party join the Communist Party. But nowadays, there's much more choice in China. So I think we feel that in China nowadays, because there's more choice, the involuntary Communist Party membership is less likely.
Let's turn then to whether somebody's membership in the party is meaningful. The Foreign Affairs Manual says that it cites several Supreme Court cases, including the Roosevelt case that I mentioned. And it says, in each case, the alien had not had a commitment to the political and ideological convictions of communism. How does a consul figure out what somebody's convictions are?
Well, it depends. I think, again, case by case basis. If I'm interviewing somebody who works for CCTV, China Central Television, and that person happens to be a documentary filmmaker, and the documentaries are all singing the praises about how great the Chinese Communist Party Chinese Party is, well, you tell me. If you are a mayor of a small to mid-sized city, I think you're probably a meaningful party member. However, I think the most difficult aspect of Communist Party membership is during the interview to determine, let's say, a state-owned enterprise. What is meaningful and non-meaningful within a state-owned enterprise? Where is the cutoff between just being a worker and being a decision maker?
Yeah, that's the question.
I think it's a judgment call.
Right. So let's turn to some procedural issues. First is, if you take a look at the Form DS-260, that's an immigrant visa application, it asks whether the applicant is a member of or affiliated with the Communist Party or other totalitarian party. Interestingly, the scope of that question is a lot narrower than the ground of inadmissibility. For example, it doesn't ask about party membership. It doesn't ask about membership in or affiliation with organizations that are affiliated with the party. And that's different than the Form I-45 if you have adjustment cases, which asks really broadly about any affiliation or participation in any organizations ever. So here's a policy question. Why is the DS-260 question so narrow?
I don't know the answer to that, I have to admit.
And the Form DS-260, when it asks, are you a member of the party or an affiliate of the party, we just talked about those Supreme Court cases that say membership is not present if your association is not meaningful. So somebody, let's say that they're a mayor of a city and a party member, thinks that their membership is not meaningful, and can they answer no to that question without being subject to a potential charge of misrepresentation?
I think that the person would have to answer yes in a case like that. And then the officer would continue to interview and determine through the interview if the membership was being filled out.
Now, I understand your point of view. My point of view as an attorney would be that under the ABA's model rules of professional conduct, I have to zealously represent my client. And if I have an argument that based on some facts and some law can't be frivolous, that my client is not a member because their membership is not meaningful, maybe I have to make that. Is the client going to be punished for my zealous advocacy?
I think the client has to answer the question just based on what it says. So the question says, are you a member or affiliated with a totalitarian communist party? The answer would be yes.
Okay, so we can agree to differ there, right? Still on procedural issues. The consulate sometimes issues 221G notices, as you said, after the interview, asking for the resume, including, as you said, travel history, and asking for answers to 9 questions about party membership. For example, why did you join the party? Have you held any offices in the party? Are these 221G notices issued in all cases where it appears the ground of inadmissibility may apply?
Well, not necessarily, because we know that a lot of Communist Party members, probably there's an overlap with the technology, right? Technology and all this. So what we want to do is, we may actually issue the same 221G form to somebody who has a scientific background, some sort of background in sensitive technology. So that form is like one and the same for Communist Party members and for people with these sensitive backgrounds. It's on, I believe the form is one side looks more at the Communist Party affiliation questions through a resume and travel history, and the other side is focused more on the professional history.
So for people with technical background, you're going to ask them, why did you join the party?
No, it doesn't say that. It just asks for.
It's a piece of paper. That's all.
Yeah.
Okay. So not everybody who maybe is inadmissible under that ground will get the 221G notice on that. Okay. Would officers sometimes follow up on those questions during the interview, or you just want to talk about that in writing?
Well, again, we're balancing our workload, so sometimes you're not going to be able to make a determination right there at the window. So we want you to at least give us something in writing, and if need be, we'll call you back for a second interview. I'll give an anecdote, which I think is quite amusing. So we had a guy who was a colonel in the People's Liberation Army Air Force. He taught at the party school, and he sat at the window and he kept denying that he was a party member. Well, I mean, I'm not a mind reader, so I can't say for sure that he's not a party member, but all indications were he was a party member, right? So when you have a situation like this, you can stand and argue with the applicant for like 10, 20 minutes, and that doesn't do any good. So here, take this paper, give us some more information, we'll reevaluate, and then take it from there.
And just to follow up on that case pattern, if you're a lawyer and your client tells you they're a colonel in the PLA Air Force, it doesn't matter whether they're a party member or not, because if they have a higher rank in the military, they're affiliated with the Communist Party, but they're not a member. We're getting near the end of the procedural questions. Just a couple more. When the client submits a response to that 221G notice, is a legal brief, if it's well written from an attorney, helpful or a waste of your time?
Like I said earlier, any briefs are helpful if you give us a very tight narrative we can focus on, in addition to the questions answered on the 220G form.
Is a security advisory opinion always required in these cases?
Okay, so if we're going to find somebody not eligible for the visa because of a Communist Party membership or association, we have to send it into Washington because we don't make the final determination. Washington looks at it and they will make the final determination.
So if somebody claims to be a non-meaningful member and you think, yeah, that's right, you don't need to send it into Washington, then we ask them. And if it is sent into Washington, who deals with it?
There is an office that deals with within the Security Advisory Opinion Office.
Great. The VAN says it's called the Office of Screening, Analysis, and Coordination in the visa office. How long are these SAOs taking?
Well, they used to take 6 months, but lately in the last 18 months, they've been taking much longer, with some going closer to a year. We've received inquiries from the applicants themselves and from their lawyers, and we will be in Washington and ask them, can you please follow up, just to make sure that these cases are not sitting on somebody's desk.
That's helpful. Last couple of questions. Is there anything that attorneys representing applicants in these cases should do or not do that we haven't mentioned?
Not really. I mean, just give us the facts and be as truthful as possible.
All right. So I've been hiding the ball. At the beginning, I said there's like 90 million members of the Communist Party, and we heard from Benjamin that there's about 35,000 IV applications adjudicated each year in Guangzhou. What's your guess as to how many people are found inadmissible each year on this basis? In 2017, according to the State Department statistics, there was 15 people found inadmissible for party membership. The prior year was like 46. So Benjamin, why is it that so few people appear to be found inadmissible in this round?
There's really no good answer to this. Sometimes when I fit in at the window and I'm interviewing, I've actually made the joke before talking to the applicant. I would say the same thing. I'd say, so there are 90 million members of the Chinese Communist Party. It is the largest political party in the world. Why is it that I don't see any of those people at my interview? And they would laugh and say, well, we don't know. We're not. And then some people responded, caging up, they said, well, maybe those people don't really know.
And, thanks so much for being such a good sport.
Do you ask Gigi's question?
Is there a presumption that a person who is a managerial employee in a state-owned enterprise party member?
Actually, I would say no. So we've actually met with several good contacts of ours, honest contacts who work for state-owned enterprises, and we've asked the question, say, in order to be a high-level manager in a state-owned enterprise, do you have to be a Communist Party member? And these contacts have told us not necessarily. In fact, in some Chinese SOEs, you may have a board meeting where only one board member is a party member. But you may also have a commissar, if you will, who sits against the back office, and he's the guy watching and reporting what is happening in the SOE to the party. And these contacts have told me, it's actually not easy running an SOE in China because you can get punished twice. The market will punish you if you don't perform well, and then the party will punish you as well.
Hey, Eugene, keep in mind what we mentioned, that if the person is not a party member, if they're not rank and file, if they're at a certain level and they're making policy or carrying out higher level policies, even if they're not a member, they may be considered an affiliate.
I'm just glad that Benjamin is the Avadi chief, because I don't want to talk about anecdotes, but in past years gone by, depending on who the chief is, I've actually had people call up a state-owned enterprise and presume and say, I'm all your vice general managers, party members, and use that as evidence that the receptionist who answers the phone gave evidence that the person is a member of the Communist Party and could get it bogged down for a year or longer.
Right. Well, we're thankful Benjamin's IV chief then. So I just want to quickly go over some of the questions that people had. The recent change to the ban, 9 ban 302.8 to B3, and B2 talks about the added language of public charge determination, and then the I-864, instead of being normally sufficient to meet the analysis, is now a positive factor. So how is opposed to applying the recent changes to the ban regarding the effect of I-864 on public charge determination? So if at all.
Well, I mean, I think that, no, I don't have a good answer for that, because I told this myself. No, I don't think we do anything differently than we have been doing it before. So no, I wouldn't say that there's a those for.
I mean, maybe we found them 221G in the past because they didn't meet the public income guideline, and I would say, well, you need to get a joint sponsor. Okay? And we put in 221G. Now you put them in for 4A. But 4A is a category 2 hit. It's not category 1, which means when you come in with additional evidence that you've gotten a new joint sponsor, then we can issue that.
And then the last question is, so when USCIS reaffirms either an I-130 spousal petition or a K and sends the case back to Post for a second review, would the Post again directly return the case back to USCIS without notifying the beneficiary for another interview if the Post is still does not find a valid marriage in the case? And any chance for the beneficiary to submit evidence, re-interview before the Post returns the case back to USCIS? And how would the Post deal with the case is reaffirmed by
Well, I mean, this is really rare, I think, and no, we would not. Well, we would follow the guidance in 9FAM 504.2-A2, and that would be when to suspend action return petitions. So ID basically is the bottom line. So.
Yeah, so if the case is reaffirmed by USCIS, we may disagree with it. You know, these cases take a long time, right? Sometimes they reaffirm three years later. People have already left Post. The officers will be interviewed. I think it's only fair to bring them back in Medicaid of these cases for a second interview. We'll of course look at the revocation memo that was written, because sometimes if the revocation memo was written so poorly, you know, we're not going to be able to make a decision based on that revocation memo. We're probably going to have to bring them in for a second interview.
Sure. Well, thank you so much, Russell. This is the end of your marathon, so thank you for taking the time and being with us today. Benjamin, I want to thank you, being a little under the weather that you're continuing to try on, but unfortunately you're only on lap 1 of your 3-lap marathon. So look forward to Benjamin coming up after lunch. All right, thank you very much for all you guys.
Thank you. Please wait one moment for a few housekeeping points. All right, we need to change the program during lunch a little bit. We thought we were going to be able to bring the food in and have it and eat in the room, but they've asked us not to. So we can only have lunch out in the break room. Please, we're going to come back at 1:30 so that we can hear the presentation from our conference matron. And then we'll start back up at 2 o'clock. So please be sure to come in. What's that? I don't know it. I don't read your sign language way.
The Philippine case.
Thank you. And there was a comment about the case in the Philippines. We would like to point out one of our very own BDC members, Wayne Wade, and that was one of his cases.
We did that slide.
Thank you for that. We do want to recognize that. That was good work by one of our very own members. One more housekeeping point. Most of you, when you registered, we identified if they're going to join us for dinner tonight. We'll go straight from here downstairs. There's a few people that haven't notified me yet. So if you don't remember being asked, come up and I'll make sure we tick you off if you're going to join. And Nikki, I think, we're on this. So again, lunch is over next door in the break area. And please plan to be back at 1:30. Thank you.